your motion.
And that's fine, Mrs. Mayo. It's in response, Mrs. Oaks is bringing forward an issue and Mrs. Denler is bringing forth an issue. So the issue here is the posting of contracts, and the posting of contracts comes with the cure and correct motion. So in this case, we don't have that because you're denying the cure and correct.
But I was suggesting that they could be done separately, and we could first deny say that there was no Brown Act violation and occurred, and that it's a time barred issue, and then when that's been agreed to, we can move on to the contracts. I think those are two totally separate things, and I don't think that they should be put together.
And that's fine, we're taking discussion here. So Mrs. Oaks raised that point, and if she wants to discuss that further.
I just don't see why we can't add it in here so that this is a more complete motion, so that, because I do think that the public deserves the right to be able to see those contracts.
I agree. Would that be something you would add, Mrs. Mayo, or would that be something?
Well, I am prepared to make a separate motion because I believe that there are two issues here. I believe that we should consider the complaints first and decide the resolution about the specifics of the complaint. And then, as you indicated, we could consider a subsequent motion that would ask staff to review the contracts and then provide, I have more details in my motion regarding revising the contracts and presenting both revised contracts and the contracts as they stood on April 23rd as a motion, and that would come back to the board on January 28th.
Okay, I said this Monday night, I'm gonna say it again. This is a classic example of making a mountain out of a molehill. It's a very, very, very simple process, and this is convoluted, it's distracting, and it actually, to me, does not in any way, shape, or form address the responsibility that we have to the public to do things better. And once again, I'm gonna say in this motion, I am in complete disagreement with the idea that you make any sort of accusation or non-accusation about guilt. I think that is not the relevant issue here. I am also stunned that we would have anything in here that sounds condescending and patronizing on top of it. And absolutely, I think to deny the cure and correct demands is to be foolish and unresponsive to the public. And instead, we're focusing, to me, on trying to decide that there is no guilt, and that is not what I would put as the purpose. I would put as the purpose, do we want to try to do things better? It's very, very, very simple to me, and I think this has become a mountain instead of a molehill. So I absolutely find this absolutely the wrong direction to be going.
I have a parliamentary inquiry. Is there, at what point would it be in order to offer an additional substitute motion, or is that possible?
Well, we were gonna break at 8:30 and go into closed session, but, we've made agreements.
You may offer an amendment. If I could just suggest, it probably makes sense to vote on Ms. Mayo's first and then offer your amendment. But at this point, you could offer something that would be a substitute to her amendment.
Well,
I'm still treating this as a substitute motion with a slight tweak. We're in a different arena here. We're not in an amendment. I don't mind, because we haven't determined that this substitute motion is one we're going to act upon. We're consolidating it now. Mrs. Mayo wanted to add some pieces to it. So maybe Mr. Lawrence, if you want to share what your thinking is.
So, at some point, I think I'm going to be hoping that we start clean, but I'll start, since the chair has ruled that we'll be speaking expansively about this. I'll give my perspective on the issues at hand. So first is, why are we discussing this topic? In my opinion, it's not because of Ms. Lack, Ms. Minion, or frankly, you, Ms. Hanson. It goes to the central foundation that a board, as trustees, we must continually earn the trust of our constituents. In the case of the contract extensions, the previous board failed and failed miserably to meet the standard. I believe their actions were reckless and irresponsible. How do we ask the public to trust us, to spend hundreds of millions of dollars, unless we act in a way that's prudent, thoughtful, and transparent? The public has an absolute right to see and comment on proposed contracts. It's not just a legal obligation where you do it as a matter of course, but I believe that it's also, it creates better decisions, because when you open things up and allow for the public to have input, you're reflecting the values of your community. And so we cannot abdicate our responsibilities for the sake of convenience and expediency. And I refer to in December when it was brought up that this board should give autonomy to the superintendent and to Pete Peterson to enter into millions of dollars of contracts on our behalf without our seeing those. I think that was, I could not in good conscience possibly do that. However, just because something is frankly stupid, does it then become illegal? So for me, then I turn to the Brown Act allegations themselves. And this is an issue where we've received counsel, outside independent counsel. I've also done my own research. I dusted off the constitutional law book from my undergrad studies at UC Santa Barbara. I didn't get straight A's at Santa Barbara. It's a place of beautiful weather, beautiful beaches, attractive young ladies. I was distracted by all three during my time there. But I did get an A in constitutional law, so I actually went and looked at Marbury versus Madison, which is kind of the foundation of America's judicial system, and looking at the differentiation between a ministerial act and a triggering legislative act. So when I look at that, in this instance, the original contracts that were presented on April 23rd met the bare legal minimum of that they were presented to the public. And that vote was the substantive, definitive legal act. It was a sloppy and haphazard way to do business. As Ms. Hanson, I was there that evening, as Ms. Hanson pointed out, allowing the superintendent's contract to stand with the $25,000 housing allowance. How do we possibly roll that over? How's that handled? But the contract extensions took effect when the legislative act took place. And I think we also have to keep in mind that 5 educational professionals made decisions about their career plans and their lives based on those extensions. So we have a legal and moral obligation to honor those extensions. When I look at Ms. Minion's complaint, it's titled Brown Act Violation, Demand for Board of Trustees to Cure and Correct the Legal Action that took place on April 23rd, 2012 for item 16.7. Her letter is dated December 21st, 2012. It's nearly 8 months after the alleged violation. The Brown Act states that complaints must be filed within 30 or 90 days, depending on whether it took place in open session. Therefore, Ms. Minion has no basis for a complaint. Ms. Lack's allegation is around the signing of the contract extensions by certain previous and current board members. For me, her allegation lacks sufficient merit for the following reasons. 1, there's no evidence, and she offered none, that the board members met to sign the contracts. Second, if they did meet to sign the contracts, that would be a ministerial act, and it is legal. Third, in my mind, these contracts, they're pieces of paper which we're referring to as contract extensions, but they're not fully valid contract extensions because they've not been countersigned and I've not seen a signature on them. So we never had the opportunity to present these to the public. The previous board went out of order on this. You bring contracts, you present them, you gather input, you amend, and then you vote. But the way we remedy this, I don't think that it's necessary to have a finding to stretch the Brown Act, because I don't find any evidence in this instance that the Brown Act was violated. However, new contracts should be drawn up, presented first, allow the public to comment, have the changes incorporated, and then ratified, and then signed and countersigned.
Okay, and in that is, there are several legally arguable points in that, and that's one of the problems in this situation like this. And to me, it comes down to a simple set of values, and that is, are we gonna be responsive to the community and do things better or not? And to me, it's quite simple. And in that, you know, there are legally arguable things around, the date of submission, and as I've said, that's something